recording. There we go, and then we might as well start up. I know that Irving's going to join us in 10 to 15 minutes. So there we go. We have regrets from Rob and from Matthew, from Andrea and Gil. I think that's who we had. Originally, John didn't think he could make it, but then he managed to do so. So we're grateful for that. So thank you, John. And so anybody else who joins us during the meeting, then I'll certainly let them in. Welcome back, everybody. It's been a while. It's been 4 months, right? So hopefully everybody had a wonderful summer. We talked about that a little bit, and it certainly went. For me, it certainly went by fast. But hopefully everybody had a nice summer and a nice Thanksgiving if you got to enjoy that. Okay, so so that's we've got the regrets out of the way. So we have an agenda that I circulated to everybody at the end of last week. So hopefully you all have it. So can I have a motion to accept the agenda as distributed? Howard, and seconded by John. We'll take that. All in favor? Great, thank you very much. Likewise, we have minutes from our June the 14th meeting, which we circulated this morning. Apologize, it's a little late, but got it out to you. So can I then have a motion to adopt the minutes of June the 14th? Brendan, seconder. Howard, thank you very much, and approved. All right, guys, so let's move on to news announcements, what have you. I was hoping to have a bit of a report on the World Congress. I was going to call on Howard and Irving. I can call on Howard, or I mean, I know that John and Peter were there. Or do you want to wait for Irving to be here to participate in that? So it's up to you guys.
We can wait for Howard or Irving. Yeah.
Sure.
Yeah, my suggestion we wait for Irving, and both Peter and John saw much more of it than I did, but Irving can give us a good sense. I'm curious about how the budget all worked out, and only he can speak to that. So
super. All right. So when he joins us, we'll stop where we are and have Irving give us a report, which is great. Notwithstanding the summer break, Howard has still continued to post the newsletters for the CCGA on a regular basis, and so any issues of interest in that are certainly open to be discussed by us. Is there anything in particular that in the news that we want to bring to the attention of the PRC and or follow up with any kind of diligence we can have? You good?
Sorry, I couldn't get my mic off fast enough. Miles, just a quick point from the last one back in June, when there was all that discussion regarding the Supreme Court ruling down cruel and unusual punishment for the 50 some odd years for eligibility for parole, which I didn't capture in the minutes, but I think, didn't we talk a little bit about, is there something that we, meaning PRC, might be able to look at in terms of finding, because interesting, the government hasn't done a darn thing about it, but you know, they've just put things back to the old status quo. And what about certain individuals that, you know, multiple murders, and we keep seeing that occurring more and more, that you know, maybe 75 years is cruel and unusual, but what about raising it up to eligibility for 30 years instead? You know, there's still a hope for the person, but you know, it's just something. Actually, I feel quite strongly about that. I think it was a wrong decision, but that's just me. And I just wondered if there's any impetus from the PRC to further look into that, or should we just leave it?
Well, yeah, thanks, Peter. Yeah, we talked about that when the decision came out, and I think we kicked around, you know, perhaps a more workable upper limit would be 40 years, if my recollection is correct. So what would you want us to do, Pete?
I don't know. Well, you know, if there's willingness to look further into it, it would probably be very much a legal argument, wouldn't it? You know, as on that part of it, you know, because it was through the Supreme Court. I don't feel qualified to heavily look into legal matters to that extent, but you know, my feeling is that maybe we need to address it, or at least send something to the minister to say, you know, would you like to consider this? I don't know. I don't mind trying to write a letter to the minister and saying, would you consider this? But I like someone who had a bit of a legal background way
But-
beyond mine.
Yeah, and I mean, I think it's as much a social issue as it is a legal issue, you know, as to the upper end of multiple life sentences without parole. But sure, Pete, if you, why don't you prepare something for us to take a look at the next meeting, a bit of a memo, and then we can discuss it and talk about whether we want to forward it on to the minister to look at, you know, some prospective legislation, you know, dealing with it. If it's not already being dealt with already, we haven't got to the committee work yet. That's next, but I don't know if it has been discussed at committee, but I haven't heard anything.
Okay, yeah, I'll do that. Thanks, Miles. I appreciate that.
Just record that in the minutes then, that'd be great.
I've got it down.
Anything else? Okay, all right, let's move on then to business arising and updates on the committee work. So Commons, Justice and Human Rights, that's Howard.
Thanks, Miles. Just on the news thing, I guess I wasn't quick enough off the draw. I just wanted to note that I've got two new pro bono student Canada law students starting with me, starting with CCJ. I just got an email from them last week, so I will have a first meeting with them this coming week. And I raise that because they're a good source. I'll have them working on something. My obligation as a lawyer and them being law students is to give them something that helps exercise their legal training and muscles. So I'm looking for legal topics, but I will be trying to identify with them a paper they can write or a draft brief, obviously for the benefit of the PRC. So I'm open and would love to have your suggestions, bearing in mind it should be a legal thing. When we apply for this every year, I gave them a list of a series of things and encourage them to think about what they're particularly interested in. My own view is students do better work when they pick a topic that they're quite interested in, but the list I gave them is quite broad and includes things like mental health, the intersection of mental health in the criminal justice and correctional setting. It includes remand populations, which are still a travesty in our country. It includes issues about the failures of the criminal justice system to deal in a way that is more helpful with sexual assault and intimate partner violence kinds of things. So there are a number of things. The SEC has been quite active again over the last 6 months, and Peter mentioned the BCNet decision about the potential consecutive parole and eligibility periods, but they've also opined on the issue of the federal government's expansion of the rape shield. So it's not the rape shield per se, but the extension to deal with the Ghomeshi trial issue. So there are a whole host of kinds of issues there, but I really raise this to say we'll have two young, eager students, law students. So I'm open. Just send me an email, any suggestions you have. I try and pick something to help add to their legal training. So I tend to look for more legal issues rather than criminological kinds of issues, but any thoughts, suggestions, I'm quite open to. Okay, so pardon me, Miles, for that I just wanted to get that bit in for our pro bono law students. So if I may now, I'll turn to the question of the report on the Justice Committee and Human Rights. I'm sorry, I'm stumbling over my words. House of Commons Standing Committee on Justice and Human Rights. They have been quite busy, as they so often are. Hello, Irving.
Harry.
Did we wake you up today?
I beg your pardon? I didn't hear you, Howard.
I said, did we wake you from sleep this morning?
Well, if you'd called me at 5:30, you would have.
Not likely that I'm going to do that. I hope you didn't pick up COVID. Both John and Peter said that they did from Congress. So I think there's a class action lawsuit.
I hope not. No, I'm good. Thank you.
I was just about to go to the Justice and Human Rights report, but we had deferred the issue of the Congress until you joined us. Miles, you're the chair. At your pleasure. Do you want me to go on with Justice and Human Rights?
No, actually, let's go back to when Irving sits down again. Let's call on Irving to give us a report on the Congress, and then we'll start with the committees at the top with you, Howard, once Irving is back with us.
Yeah. So is the hottest item that Peter and John got COVID?
So far.
Oh, jeez. Anyway, I thought it was the most successful. I'm not the only one who thought so. Most successful Congress. I got lots and lots of positive comments from folks coming from all over the world and so on. In the end, we had, I think, about 300 people. There was a few cancellations because of various and sundry reasons, including visa problems, obtaining visas from countries like Vietnam and stuff like that. African countries in particular as well. We had probably at the end of the day, we probably had representation from about 31 or maybe 32 countries. And I thought it was a great Congress. I did not hear much of a negative nature, except for the fact that Peter and I guess John, I know Frank Porporino got COVID, but hopefully not too many. It's a disease we know well now since 2.5, almost 3 years, going on 3 years. You don't know, people who don't have symptoms can pass it on, and people who have symptoms don't pass it on, and so forth. We've been lucky, frankly, but I got all 5 shots, the 3 boosters, and so on. I'm looking forward to the 6th shot, quite frankly. Does that work or does that help? It doesn't hinder, I'm sure, but we've also heard cases out of, obviously, people who've had their shots and still get COVID. So Peter, is Peter on today?
Yes.
I don't know, Peter, John, I don't know why you guys got COVID, and we're sorry for that. Hopefully you're feeling better today. And, there's a risk anytime you get together with people in any kind of environment like that. I, for one, tried to wear the mask, and I was probably one of the only ones, aside from actually our delegates from Japan. Many of them were wearing masks. You may have noticed, Peter, John, for most of the time, not all the time. But aside from that, I don't recall anybody wearing a mask. I guess I can certainly understand, because you get fed up wearing the mask, right? But it was a large audience, and you don't know who you're milling around with. There's always that risk, but hopefully nobody got too ill. So, if you have any questions, guys, I'd be pleased to answer. No?
Irving, how does the budget look? Is it a little bit early to do the accounting?
I don't know. This is not a money maker. As I mentioned to our board, I think you were on the executive call a month ago. It was expensive running this. We thought we'd have a much larger audience. We were trying to follow the pattern that was set certainly in Sydney and probably others. Offering lunch and breakfast every day and the evening events and so forth and so on. And because of COVID, we didn't get 500 people attending. We had, like I said, 300, something like that, something in neighborhood of. We had 347 registrations, but a number didn't show up. Some canceled and so forth before the Congress itself. Let's say we're working with about 300, including students and such, and so on. It's going to be tight. I can't even tell you, frankly. We broke even, maybe we made $1. I'm not certain. There's all kinds of bills that we just had to cover unexpectedly. They were off the budget, and the cost of the hotel, the food was a fortune. There's no other way to put it. And costs have gone up since COVID. So it's a double whammy in a way, in terms of trying to organizing a conference when the outside, the macro factors change, such as COVID. So you got less participation, fewer people registering and so forth, but your fixed costs are always there. And the fixed costs have, frankly, between 2019, our last conference, and this one have gone up substantially. And of course, the food costs, and you try to estimate as much as we can. And again, because some people didn't show up, we covered what we thought was going to be the requirement in terms of food and so forth. You don't want to be embarrassed with that scenario. So it's going to be tight, and I won't know probably for a month until all the bills come in and so forth and so on. So that's the best response I can give you, Howard. But to me, at least, and I think to our board certainly, and our partners, I think it was important that we not embarrass ourselves. That this was a presentation not just by CCJA, but it was Canada, in fact, and we were partnering with the public safety portfolio, which is CSC, Parole Board, RCMP, and public safety itself. So we had to do what was required, and I think we put on a very good show in that regard. I don't think there's anything to be embarrassed about. Again, I got a lot of positive kudos from folks from, I think I mentioned, from Europe in particular, from Japan. They were, they were beyond over the moon, so to speak, with what we managed to do. And we had tremendous speakers. I mean, we had folks who are leaders in their expertise area, right, from across the world. So that was something.
Well, thanks, Eric. I mean, on behalf of the PRC and myself personally, which I'm very sad that I couldn't attend, but thank you very much. You and the committee that worked on this. It's a tremendous amount of work to put this kind of thing together. And by all accounts, it sounds like it went wonderfully. So, thank you again.
Thank you.
Yeah, very, very, very much appreciated. Any other questions or comments for Irving on the World Congress?
Can you hear me, Stefan?
Yeah, Stefan.
Yeah, Stefan was there.
Hi, everybody. Yeah, I thought it was great, and Cecilia enjoyed it. Unfortunately, like John, she tested positive with COVID 2 days after we got here, and last couple of days she's negative, so she went back to work. But I was lucky I got off the hook. So I don't know, maybe it's my Ukrainian blood or something resisted it. But I really enjoyed the Congress. Irving, and great to see Howard and John, and it was just a really wonderful experience. Thank you.
Thank you. Just to touch on that, what you just mentioned, John and Peter may want to sue us because he got COVID, but we don't know, and they can't prove where they got it. And just as a kind of an anecdote, our AV guys who didn't mingle with the crowd, particularly they stayed amongst themselves behind the desk, managing the audiovisual requirements and translation. They all got COVID. So where did they get it? I don't know. But I'm told they all got COVID. So maybe they went to a restaurant, maybe they flew together, drove together. I don't know, whatever. But as we all know, I don't want to be repetitious, this is that kind of an illness where you don't know what you got until you got it, right? And you don't know if you pass it on to anybody because you don't know if you have it. So that's where it's at. Hopefully, they've got a new booster that's soon going to be available, and I'm sure they're going to be subsequent improvements in the vaccines if people want to take the vaccine, and maybe one day we'll see this in the rear view mirror entirely. In the meantime, I think we have to be cautious. My perspective was to try to the degree possible, mitigate the risk for myself. I didn't want to get sick during COVID, and because I had a lot of things to manage during the course of the. I meant during Congress. So I wore a mask whenever I could, obviously not in front of the microphone and not at the banquet. We were all sitting together and so on, but I didn't, I tried to be as cautious as I could without going overboard. Let's put it that way.
I think from John and my perspective, it's really a matter of the East ganging up on the West one more time.
Well put, Peter.
No comment.
All right, guys, let's return then to the updates on the Justice Committee. So again, back to you, Howard, please.
Okay, then. As I was saying, Justice and Human Rights continues to be quite busy. They've had 8 meetings since our last PRC meeting on June the 14th. I'm going to talk about 4 things generally, starting with the thing they are most recently working on. They've held 4 meetings on the topic of the government's obligations to victims of crime. This was something they had agreed to at a business committee business meeting in March. And their description simply says, a study of the government's obligation to victims of crime. My sense of it is that it's quite broad, because included in the decision to start on this study, they've noted specifically to include evidence and documents gathered by the committee during the second session of the 43rd Parliament in its study of the Canadian Victims' Bill of Rights. So that anything they gathered as evidence in relation to their study of the Harper-era Canadian Victims' Bill of Rights will be considered. I've noticed as well that some of the most recent witnesses before the committee are talking about the Ukraine International Air Flight 752, and you'll recall that this was the one that was shot down over Iran by the Islamic Revolutionary Guard. I was tempted to say allegedly, but they have actually admitted their fault, although they claim it was an error. So this committee hearing is potentially quite broad when it includes victims of an event that occurred over Iran. So anyway, I could talk forever about any one of these items, and I won't do that given the time we have available this morning. So the second item I wanted to mention was the August 24th hearing on the nomination of the Honorable Michelle Obonsawin. I hope I'm saying that correctly, but you will all have seen the press. Justice Obonsawin was a trial level Superior Court judge here in Ottawa and was nominated by Prime Minister Justice Trudeau to join the Supreme Court of Canada to fill the seat vacated on September the 1st by the criminal justice luminary. So she has actually taken the seat. She's now on the Supreme Court of Canada. You may know she's a fairly young woman. I don't think she's 50 years old yet. She's in her late 40s. So she potentially will be sitting on the court for a long time. There was a very public hearing that you probably have seen. It's certainly available on YouTube and all of that, where Justice Obonsawin answered questions. It's not actually available on the parliamentary website. It was sometimes it's billed as a meeting of the Justice and Human Rights Committee. More accurately, should be considered a special committee meeting, but it is not listed anywhere on their website. So members of the Justice and Human Rights Committee, the Senate Committee on Legal and Constitutional Affairs, a Green Party MP was brought to the committee as well. So it was quite a public hearing where for about 2 hours, Justice Obonsawin answered questions and seemed to handle herself quite well. What you will notice on the Justice and Human Rights website is a subsequent meeting on the same day where the Minister of Justice, David Lametti, and the chair of the Independent Advisory Board for the Supreme Court of Canada Judicial Appointments, his name is Wade McLaughlin, the Honorable Wade McLaughlin, answered questions about the appointment process and the specific appointment of Justice Obonsawin. One of the interesting things about this is not just during the committee hearings, but on the Justice Canada website, they've published a lot about the committee, the appointment, the independent advisory boards process, and how they arrive at the judges or the candidates they recommend to the Minister of Justice. And so both Justice Obonsawin's background and the appointment process have been opened up considerably to the light of day, considerably more than anything I had seen before. Justice Obonsawin has been praised as being the first Indigenous judge to fill a seat on the Supreme Court of Canada. So that's clearly of note as well. Moving on down, I wanted to talk about the third item. Third item I wanted to mention was the review of the Protection of Communities and Exploited Persons Act. You'll recall we talked a lot about this before the summer break. This was a bill. It was Bill C-36, passed during the Harper era to respond to the Supreme Court of Canada decision at Bedford. So Bedford struck down the criminal code provisions dealing with prostitution and the sex trade. The Harper government came back with a fairly strong bill that decriminalized the provision of the services, but continued to criminalize anyone who's purchasing the services. During the committee hearings, I had mentioned to you last spring, there was a lot of criticism from participants in the sex trade that the Protection of Communities and Exploited Persons Act endangered them, that the way it had approached the regulation of the sex trade, or I should say the criminalization of the sex trade, endangered their lives. So the committee the committee has prepared and presented their report to the House of Commons on June 22nd. The Conservative Party of Canada appended a dissenting report. The NDP appended a supplementary report. The supplementary report recommends decriminalization completely of the sex trade. The Conservative Party's dissenting report obviously takes a strong position against that. The committee's report itself, there were 17 recommendations. The House of Commons Justice and Human Rights Committee said, among other things, that they recognize that sex work is made more difficult by the framework set by the Protection of Communities and Exploited Persons Act. So the committee, and they're asking the government of Canada to recognize that. Of course, the Conservatives of Canada, Conservative Party of Canada is opposed to that. The report is full of criticism of the act and its potential for endangering sex trade workers. However, they stop just short of adopting or arguing for decriminalization. Instead, they talk about elimination of a few of the prohibitions in the current legislation and more study and consultation. I think the bottom line on this is having tabled this on June 22nd, we now are waiting to see the government's response to their report, which the committee has requested. So we'll see what happens, whether the government is prepared to consider a complete revision of the Harper-era legislation on the sex trade. The last thing I wanted to mention, and again, I could expand on any of these, but I'm trying to be brief. You remember in April, the Standing Committee had issued a report entitled "The Shadow Pandemic: Stopping Coercive and Controlling Behavior in Intimate Relationships." They also requested that the government table a response to their report. The government of Canada has done so. It's dated September the 15th, 2022, this year, of course. It actually takes the form of a maybe 5-page letter from the Minister of Justice. You won't be surprised by their response. It talks about all the wonderful things the government has done. It talks about of course, it always starts these things as they always do, that the government of Canada considers this a priority for them. They're watching a couple of private members' bills, one of which proposes the criminalization of coercive behavior prior to the time that it gets to the point of a criminal code offense of harassment or violence of that nature. But it's kind of a wait and see approach. They talk a lot about discussing this with the provinces and territories in their FPT forum. The response from the government is available on the Justice and Human Rights website. I have a link for it if you're interested. It's under the home page of Justice and Human Rights website, so it's there for you. It's interesting to read, but again, it reads like so many federal government documents. It talks about all the wonderful things they're doing, how they take this seriously. They're not sure that they're prepared, but they are talking about a new offense with provinces and territories, and they're watching the private members' bills. It seems that they're prepared to let the private members' bills carry this. One final comment is the private members' bills talk about a new offense short of the current criminal code offenses, but they also talk about education of the judiciary and other actors in the legal system to understand that coercive behavior is really a lead indicator in some cases of what may follow. The problem is it's really difficult to know how to predict when something follows, and do we want to keep criminalizing, moving further back in the chain? It's a little bit difficult to prove coercive behavior, and particularly when it's mental, and in obvious extreme cases, it's not so difficult. But anyway, have a look at that if you're interested. We can talk some more about any or all of those, but I don't want to take any more time than I have already, so I'll conclude my comments there.
Thank you, Howard. Wonderful, as usual. Any comments or questions for Howard on his report? Okay. Next is the Commons report for public safety. So just a few minutes before the meeting, I received an email and an attachment from Rob on behalf of Rob and Gil with respect to that committee's work. I don't propose to go through it. It's there for everybody to read. He just notes that there's been 7 meetings since we last met in June. The two issues essentially that he sets out in his brief memo, or they both said in their brief memo, is the meetings with respect to the allegations of political interference in the 2020 Nova Scotia mass murder investigations. Although both Rob and Gil say that that's not particularly directly relevant to our work. And then they also discussed the committee's work on an assessment of Canada's security posture in relation to Russia. And in that regard, no evidence has yet been called at committee. So that's pretty much what we have for that. Next, we have the Senate's Legal and Constitutional Affairs, and Brendan, that's you.
Yeah, thank you, Miles.
You
So the committee has met, actually, they've been quite busy since the beginning of September. They've met 6 times since our last meeting, like I said, mostly from September, mid-September till now. They're discussing Bill C5, which, if you recall, is the bill that we submitted a brief for on removing mandatory minimum penalties, as well as the changing eligibility criteria for conditional sentences, and as well as diversion issues for drug offenses. It seems like the committee is just about at the end of their consideration of this bill. I think they might meet once or twice more. In their last meeting, they said they would meet again towards the end of October, and then to be followed by a clause-by-clause consideration of the bill. What's interesting, I think, that's going on is a lot of the comments are quite unanimous in exactly what they're suggesting. They're perhaps not unanimous, but they're very, very similar, and most people are on the same page. I would say that the majority of the attention has been paid to the lifting of mandatory minimum penalties in certain cases. So the committee has had witnesses, many lawyers. They've had representatives from the Canadian Association of Chiefs of Police, Aboriginal Legal Services, scholars such as Jonathan Rudin and Kent Roach have also appeared before the committee. They've also had a few women's victims organizations appear before the committee to give testimony. Also there were Elizabeth Fry and John Howard, representative, have also presented. When it comes to mandatory minimum penalties, most organizations, particularly most legal actors, are in favor of removing of the mandatory minimums on these of the offenses. Many have also stated that they don't think it goes far enough, that in all honesty, that we should perhaps get rid of most, if not all, remaining mandatory minimum penalties. The sentiment seems to be, well, why are we doing this sort of piecemeal? Why don't we just take care of it all at once? And in that vein, actually, and I believe this is something that we discussed at the PRC, but the idea of a safety valve in the criminal code, whereby some sort of clause where it would be written something along the lines of the judges, if they believe it necessary in certain cases, they can choose to not implement the mandatory minimum penalty. And so that's been, I was a little surprised at how often that's come up. Interestingly, that was also a suggestion made by the Canadian Chiefs of Police. They suggested the safety valve option as opposed to taking out the mandatory minimums. They're particularly against taking out the mandatory minimums for gun offenses. But like I said, I thought it was quite surprising that even they brought up the safety valve option. Nevertheless, the Minister of Justice appeared at one of the earlier committee meetings, and he stated quite frankly that he did not think that that would get support in the House of Commons, whether it be from opposition or even within the Liberal caucus. He suggested that there would be quite a bit of pushback and that the safety valve option is not politically viable. A few other things that I think are really interesting with the ongoing discussion of this bill is that because of course this bill was introduced in the House of Commons last year, it continues to go through the Senate, but since that's happened, the Mass Casualty Commission out in Nova Scotia, and then has been ongoing. There was also the tragic events in Saskatchewan over the summer, and particularly the senator from Saskatchewan, I believe it's Senator Batters, has been saying that has mentioned something along the lines of, well, perhaps Canadians were on board with this bill when it was first introduced, but given the recent events, that Canadians are not comfortable with removing mandatory minimum penalties, partly because the individual responsible for the attacks had quite a lengthy criminal record. And the suggestion is that had that person received more custodial, longer custodial sentence, they would not have been able to commit the crimes that they did. So I think it's interesting that the political atmosphere has sort of changed the discussion a little bit, at least for some people. But like I said, one other important thing, because I don't want to take too much time, but one other important issue that keeps popping up is that some senators are concerned that the expanding of the use of conditional sentences could essentially allow individuals who have committed sexual offenses back into the community under house arrest. The Minister of Justice himself, as well as other witnesses, have been sort of asked about that possibility, and the answer is, I think, what we'd expect, that of course maybe that could happen in some cases, but judges understand that sexual offenses are serious and that a conditional sentence would most often not be appropriate for a sexual offense. So the argument, I think we're all sort of familiar with it, is, are we leaving the discretion with the judges, or do we leave it in the criminal code? So that's an argument, a line of discussion that keeps coming up. But generally, most people are on board with the changes of proposed in Bill C5, and with certain reservations that I've discussed. And one other thing, one final thing with this bill, people were saying if we're expanding the use of conditional sentences and the like, and also if we're trying to expand efforts to decriminalize drug possession, that we need better supports in the community for programming, and because without that sort of programming, then having people out in the community under a conditional sentence order would not necessarily be helpful, because there's no supports in the community. So I thought that was quite refreshing that there was that acknowledgement from senators as well as from witnesses. And I think I'll stop it there unless anybody else has more specific questions.
Well, we're ahead of ourselves regarding C5, but that's fine. I might as well do it now. Howard, you were also working with Brendan on C5. Do you have anything to say about that? Anything to add?
Well, just, Brendan and our two last year's pro bono Canada students did a wonderful job on putting it together. I must admit to being a bit surprised that it continues to be so controversial, and even within the CCJA, we were not able to get a consensus on a stronger statement about mandatory minimums. We did have, as Brendan has alluded in the brief, the notion of the escape valve, the judicial discretion that would allow a judge to sentence outside of the mandatory minimum when exceptional circumstances exist. We've noted that in there. I think the drafters of the brief, Brendan, feel free to correct me if I'm wrong, but I think we all felt that we should go a little bit further than Bill C5, that more mandatory minimums should be repealed. And I had suggested 3 different levels of more, most, all. And in the end, we couldn't get a good consensus, even within the CCJ on that. So we took the position of I think basically saying we support what was in C5, but we encourage the government to go further, to make further study and inquiry. That if I always say, and it's my particular rhetoric, it wasn't in the brief, but if mandatory minimums are a bad tool, they're a bad tool for everything. But they don't help the system get the bad guys, because those sentences are always vastly in excess of the MMPs. They just capture the most vulnerable, the lowest end of the blameworthy scale. But at any rate, I think we tabled a credible brief, and we're seeing a lot of support for the CCJ's position generally in the Senate committee. There's been a lot of people publicly commenting on that. I hope they get on and pass the bill, because it's relatively modest reform. We keep getting stuck in these old arguments about conditional sentences and about MMPs, and a lot of it has to do, the subtext has to do with this level of discomfort among some parliamentarians and some members of the public about judicial discretion. And I think the members who are so uncomfortable about judges exercising their discretion aren't reading the decisions, aren't looking at the factors the judges consider. And the judges have been, if you look at Court of Appeal decisions across the country, sexual offenses are being treated very harshly, and courts of appeal are increasing sentences for that. They're by no means, to use Harper rhetoric, soft on crime. But at any rate, I wish people would take a good look at the decisions, the actual trial decisions that are coming out, and that might allay their concerns. But anyway, I apologize, Miles, I'm going on at great length, but I'm happy to see the bill alive. It's taken a long time. Most of us thought it was fairly modest reform, but it seems to be stalling. I'm hoping it passes quickly.
I agree. Thank you, Brendan, Howard. Thank you. Appreciate that very much.
Thank you.
Okay, move on to the Senate Committee on Human Rights. So they've spent all summer basically dealing with the generation of a report titled "The Scars That We Carry: Forced and Coerced Sterilization of Persons in Canada." And I'll just give you some snippets from the executive summary and then 2 of the 9 recommendations. Sterilization is a surgical procedure to prevent conception. Forced or coerced sterilization occurs when sterilization is performed without the patient's free, prior, and informed consent. Canada has a long history of forced and coerced sterilization. For much of the 20th century, laws and government policies explicitly sought to reduce births in First Nation, Métis and Inuit communities, Black communities, and among people with intersecting vulnerabilities relating to poverty, race, and disability. Though these explicit eugenic laws and policies have been repealed, the racist and discriminatory attitudes that gave rise to them are still present in Canadian society, and forced and coerced sterilizations still occur. The practice of these sterilizations is not confined to our distant past, and law and policy changes are needed to prevent this horrific practice from being inflicted on others. The report highlights the experiences and perspectives of survivors and outline solutions that the committee believes are urgently needed to bring an end to these unacceptable practices. So the first recommendation is that legislation be introduced to add a specific offense to the criminal code prohibiting forced and coerced sterilizations. And the other recommendation is to provide some kind of recompense to those who have suffered as a function of those actions and policies. So I guess at this point it's out there. It's on the website for the Senate committee. So you can certainly take a look at the full report. It's not that long. It's only about 12, 14 pages long, but that's what the Senate Committee on Human Rights has been dealing with. So there we go. Nothing much we can do about it except receive it and move on. Okay, so moving now to the other items that we've had in our agenda over the past year or so, items B through, let's see, B, C, D, F, I, and J. Nothing new on those, so I don't propose to go through them for the sake of time. I had added an item K. This is something that I ran past Howard and Irving that I thought of doing some work on. I don't propose to go into it in much detail today, only because I want to do some more research before I bring it back before the PRC. But it was simply a proposal that came to mind about trying to generate interest provincially and territorially with respect to human rights codes, so that for the purposes of employment, a criminal conviction would be a discriminatory ground. And all the existing provinces and territories have positions on that. Some of them are rather liberal, some of them are not at all. So I just propose to bring that forward later. So we'll make this a waiting brief, and I'll have more to say to it next meeting, if that's okay. Okay. Next,
Miles, sorry, Miles, sorry to interrupt. I just one thought on that. You had sent an email, and I did a kind of draft response, and I never got back to it, and I apologize. One thing I just wanted to add for your consideration is there's a mechanism that's not well known called the Uniform Law Conference of Canada. It's a group that it hasn't met in the last. It met this year, but the prior 2 years it did not meet because of COVID. It really is a body that serves the provincial, territorial, and federal governments, but it looks at the uniformity, as its name suggests, of the law across the country. And it seems to me that this would be a perfect issue for it, because in fact, there is a great discrepancy across the country. It seems to me that, the conservative, or the sort of the standard position taken where provinces have enacted it under the Human Rights Code is that one cannot discriminate on the basis of a criminal record once a pardon has been received. So if we believe in pardons, you've gone, sentence expiry, some number of years without further offending, investigation by the parole board, stamp of approval, and at that point, it seems to me that's kind of the minimum standard, but it does not exist everywhere. And so it might be an idea, something we could do is write, I think the only way to access the Uniform Law Conference is through a government. So it doesn't make sense to write directly to them, but we could think about writing to the Minister of Justice to bring this issue to his attention and request that he bring it to the Uniform Law Conference of Canada. They have a civil side and a criminal side, and just for full disclosure, I headed the federal delegation a couple of years to the criminal side of the Uniform Law Conference of Canada. It's an interesting body, but there's a clear disparity across the country on how this is treated. So it's discrimination in one province, but not in another. We talk about reintegrating offenders, and of course, their inability to find a job or volunteer or do other kinds of activities because of a criminal record is a great barrier, an obstacle to their reintegration. Now, there are various protections, obviously, that one would bear in mind, like, you know, if you've been convicted for sexual assault, you know, that has to be known to sexual assault against a child, that has to be known to daycare and other child care organizations. I mean, all of those exceptions, carve-outs, we all, I think, incredibly agree on, but it's a worthwhile thing in terms of, we've had discussions here about the expunging or the sunsetting of criminal records after a certain period of time. This is connected to that. But Miles, just for your thought, while you give this some more consideration, there's a Uniform Law Conference of Canada website. If you just type in ULCC-CHIC, it'll take you to that. The body has existed since 1918. Actually, when the ULC makes a recommendation to the federal government, when it's approved on the criminal law side, there was a process when I was there that we reviewed them regularly and had to explain back to each year to the Congress why we hadn't put it in a bill, why we hadn't moved forward with it. So they have weight, and on the civil side, the recommendations have weight. So just my apologies for not mentioning this to you before now, but Miles, I think this might be a good tool for CCJA to develop something we could recommend to the Minister of Justice to take to that table.
Yeah, thanks, Howard. That's excellent. I mean, I really appreciate that. I wasn't aware of that resource, so that's absolutely great, particularly because one of the issues that was holding me back in my research was the logistics of doing this. If this required, you know, individual pushes to each province and territory, it would have bogged down on its own inertia relatively quickly. So if something like this is available, which obviously it is, that's great. I'll certainly work that into my research and take it from there. The thing, of course, is that, and Howard just mentioned, it is supplementary to all the work that we've been doing and the briefs we prepared and adopted and reflected upon with Senator Pate's work with respect to spent convictions and what have you. You know, the outcome is the intended outcome is the same thing, is to essentially allow those with criminal records to actually rebuild a life again. You know, and the spent conviction regime does it by the automatic removal of a record after a period of time. That's Senator Pate's latest position. We have our own position. CCGA has its own position that has a bit of a hard stop in it, and we'll work with that. Obviously, we can't promote anything that isn't approved by the board, and that's absolutely fine. So anyway, thank you. Leave it with me. I'll come back with hopefully something that's somewhat coherent for the next meeting, and then we'll take it from there. So appreciate that. Okay, so let's see. So let's move to criminal justice bills. So we've the first one in the Commons, we already talked about C5. Brendan and Howard have given us where we are with that, so we don't need to go any further with that. Bill C9 there's no change, and so there's a number of bills, and you'll see it in your agenda. I've marked with no change with the gray highlighting, so I don't intend to go through those. If there's no change since our last meeting, then there's nothing to discuss at this meeting in particular. Bill C21 dealing with firearms, and of course this deals with mass shootings, what have you. It's moved from, since our last meeting, it's moved to second reading and is now in committee. So that's where it is. Bill C28, this was really, we touched upon this today and in our last meeting. Bill C28, an incredibly expedited piece of legislation. This is a response to the Regina and Brown, the Supreme Court decision dealing with extreme intoxication as a defense. in a sexual assault that we talked about at the last meeting. We looked at a Globe and Mail article, came out after the decision in the court, which was May the 13th of this year, which basically struck down section 33.1 of the code as contrary to section 711D of the charter. A lot of public outcry about it. Our discussion, if I recall correctly, at the PRC was that we weren't, or some of us weren't that concerned about the High Court's decision, only in that it actually had a fairly narrow application and in a very narrow set of circumstances. But having said that, that's not the way that the public and or the politicians saw the decision. And so they moved very, very quickly to basically enact the amendment to the code to remove the defense, basically with respect to a general intent, dealing with intent to commit sexual assault. For those of you who aren't familiar with what the general intent is, I presume most of you are, but it's simply a general intent with respect to a crime is merely that the accused intends to commit it. It doesn't mean that the accused necessarily had a specific consequence or acted towards a specific purpose for the offense, and that's what we dealt with. That's why we're dealing with this particular defense of a general defense, a general intent. So anyway, the long and short of it is that since our last meeting in June, there was a first reading on June the 17th, second reading and third reading on June 22nd, first reading in the Senate on June 22nd, second reading on the 23rd, third reading on 23rd, and royal assent on the 23rd of June. So within a week, the legislation was introduced in the Commons and received royal assent. That's a pretty amazingly quick path to a new piece of legislation. But there we go. And so, any thoughts on that? I mean, there's certainly nothing that is going to be done. There's no position that we can essentially take on it at this point. It's passed and it's what it is, and the brevity of its passage is pretty indicative of the unanimous consent of both the House and the Senate in this thing becoming a law. Any thoughts?
I just feel it demonstrates a lot of the divide there is between how public perceives things and how it's actually dealt with by courts. And it's coming back to what Howard said on judges making decisions. If they could read the decisions or listen to them, if they were maybe televised, it's a whole other conversation, but public would be a little more aware of how they don't just take into account mitigating factors, but we plead the aggravating factors and we get some heavy sentences when we do. So it's the same thing. It's just, and it's a week. I'm not very old, but I've never seen this. I assume it's the quickest it's ever happened in the history. I don't know, like a week. Anyways, that's my call.
Francois, you are young. I saw a bill pass in one day with Alan Brock. When there's a political push for things, it's amazing. But I think I agree with all of your comments. Of course, the obvious conclusion to me is this bill doesn't really do anything. It doesn't really change the law. It's window dressing. It doesn't address the issue directly, and the circumstances under which someone, the new so-called new scenario where someone acts in a grossly negligent way and induces self-induced intoxication coma. Like the law has already had a way of dealing with this, and I think this bill, pardon my skepticism, and please don't repeat this, but over years of working at the Department of Justice, the tendency to do something that looks good but actually doesn't do anything, the tendency to do something and pretend it's a solution and talk about it that way, seems to win out over people's ability to actually look and say, does this make much of a change at all? I mean, when this bill was first introduced, Irving said to me, well, does it actually deal with the case at all? Well, no, someone involuntarily or unknowingly consumed a drug without having any idea of how it would affect them or its intermixing of them. Anyway, sometimes we just, our parliament just does things for the appearance of it, and I fear that this is one of those. So.
And I tend to agree, so thank you, Howard. And thanks, Francois. Appreciate your input. All right, guys, moving on. So from Bill C-202, these are the private member bills. There aren't any other common public bills. Bill C-202 through to C-29, no changes. All right, so that would take us then to Bill C-283, which had its first reading on June the 14th, the same day as our last meeting. And let me just see, this is an act to amend the criminal code and the corrections and initial release, basically dealing with okay, so what this does is it requests, on request of a person who is sentenced to imprisonment in a penitentiary, a court may, if certain conditions are met, make a recommendation that the person serve their sentence or some part of it in custody in a penitentiary that has been designated as an addiction treatment facility. And I think the amendment to the Corrections and Conditional Release Act would then therefore require that there be some sort of process to in fact do that. Irving, you know more about that than certainly I would. I mean, are there penitentiaries that are designated as addiction treatment facilities?
Not that I'm aware of, and I've been away for 18 years.
Yeah.
There are penitentiaries that are mental health facilities and are so established by provincial legislation. There's a few of them in the federal correctional system in British Columbia. There was one, the RTC in Alberta as well. I'm not sure about the rest right now. I think there was also a unit at Dorchester in New Brunswick. But you know, what we always said was that a judge's recommendation is not legislation. It's not law necessarily. So they'll frequently recommend, or they used to in my day anyway, recommend that the individual receive psychiatric care. On the other hand, he's being sentenced to a regular penitentiary, which at the time at least was not necessarily equipped to provide psychiatric care. So this sounds a bit like that to me, in that, you know, the judge's going to recommend addiction treatment, but so what? You're not in a penitentiary because you're addicted. It's because you committed some criminal offense, perhaps while you were under some addiction to various medications or whatever it might have been. However, the reality is that you know, we used to talk about in my day, detoxification. An individual starts a process by being locked up in a provincial or municipal facility. By the time he or she gets to a federal penitentiary, hopefully they've already been detoxified. Hopefully they would have received some addiction treatment in the prison, etc. So it's kind of late in the game, typically, to start at the penitentiary level. And so I don't know what this would possibly do. I don't know how they would impact the Corrections and Conditional Release Act.
Well, there you go. I mean, and I think what it's basically saying is that, you know, here's the recommendation, here's what we would like to see happen, but we also need a process to, in fact, designate penitentiaries for the purposes of these recommendations. So how far that goes, I have no idea, but there we go. It's there. So it's Bill C-283.
That's why it's a private member's bill and not the government bill. Right?
Exactly, as are the rest of these. Bill C-289, an act of the criminal code dealing with identity verification, and what this basically deals with is basically amending the criminal code to make it an offense for anybody who knowingly makes a false or misleading statement to anyone listed in Section 5 of the Proceeds of Crime, Money Laundering and Terrorism Financing Act, which Section 5 deals with banks and those kind of institutions. So what it basically is saying that if somebody lies to a bank with respect to their identity, that leads to a charge under the act, that it's a further offense. So if you're being charged under that act in the first place, that's going to be of little interest to you, but hey, there you go. Bill C-291, an act to amend the criminal code to make amendments regarding child sexual abuse material. And what it simply says, it wants to replace the term child pornography with child sexual abuse material. Okay, first reading on June the 17th. Bill 295, an act to amend the criminal code for the neglect of vulnerable adults. So it amends the code to create an offense for long-term care facilities, for those facilities that don't take care of vulnerable adults, and consider that as an aggravating factor for the purpose of sentencing for any organization that finds itself before the courts. Bill 296, increasing parole ineligibility. All right, okay, so this kind of touches on what we said earlier. So to amend the code so that a person convicted of abduction, sexual assault, and murder of the same victim in respect of the same event or series of events is to be sentenced to life without eligibility parole for 40 years, or between 25 and 40 years. So very specific in that regard. So there you go, Peter.
Yeah, got it.
Got it, thank you. Bill 299, an act to amend the criminal code dealing with life imprisonment, and what it wants to do basically is, and again, this is for you, Peter, is it wants to eliminate parole altogether. So we have a true life imprisonment sentence for cases dealing with child pornography and child trafficking. All right, so that's it for the private members' bills in the Commons. For the Senate, in government Senate bills, Bill S4, which deals with basically updating the availability of technology, electronics, and what have you to for communication and correspondence purposes for offenders, for juries, for the courts themselves. It's just basically that's what the bill is asking, is that there be some improvement to make sure that electronics can work to everybody's advantage. And it received its third reading on June 21st, and it's now had its first reading in the Senate on September 23rd. For private Senate bills, we have Bill S206, which was, this is the bill to allow jurors to be released from their confidentiality with respect to healthcare professionals. So psychological or psychiatric care as a function of the jury experience is what I understand that to be. And it's had its third reading in the Commons and first reading in the Senate on June 22nd. So for bills, Senate private bills S212 through to 248, there's no changes, so there's nothing new to discuss there. And we're actually to our last Senate, private Senate bill, an act to repeal section 43 of the code dealing with the TRC's call to action number 6. And what this is there is a provision in the code, it's section 43, which allows parents and teachers to apply a reasonable level of physical contact to children for behavior purposes. So that currently exists in the code, and what this private member's bill is to repeal that in light of the recommendation in the TRC call to action number 6, which is what that is, to repeal section 43 in the code. Okay, so all right, guys, that's not bad. That's almost
Miles, can I just
can
jump, sort of comment on 206? I think we should do a high five or take some credit for that. 206 is now passed completely. It's waiting royal assent. So it received, of course, it started in the Senate, but it received third reading in the House of Commons on September 28th of this year. So just a week or so ago. This was a brief done very skillfully by our young and talented and full head of hair, Francois. So thanks to Francois for his excellent work on that. And I think it's a small thing, but it provides some tremendous relief for some of those jurors who have been suffering PSTD and not as a result of their jury experience, which they're compelled to do, but felt unable to talk to someone about it. And I think we should take a collective high five. Francois did a great job. The PRC and the CCJ supported this. This was a win for us, and they passed it. So we're just waiting for royal assent. So good on you, Francois. Well done.
Good on you.
Thank you very much.
You have a tendency to compliment others, but you forget to talk about yourself. You work very hard on it too. So
well, we both did that.
Oh, that's excellent.
Howard, sorry, Miles. Howard, remind me, did we not insert as well the ability of the individual to talk to religious authority or religious whatever it was called representatives?
We recommended they expand that definition. They haven't followed that recommendation.
Didn't stick, eh?
No, I'm happy that it passed. Healthcare professionals, I think there's some latitude there. I haven't read the last version of it, but I think it's an idea that needed to be said. And
Yeah.
You know, that's right. We agreed the widest possible expansive definition, whoever the person felt it was meaningful to speak to. I suppose it could go too far if you included spouses or intimate. I don't know, but anyway,
It is what it is.
It's a win.
Yeah.
It's a win.
Yeah.
Wonderful, wonderful. And I just want to tell you, it's a real pleasure to be back here with you guys. So thank you very much for joining us today, and going forward is on behalf of PRC. Any other comments or concerns regarding what we're doing and how we're doing it?
Just one very, very brief comment on C-283, the addictions treatment piece.
Okay.
That was brought up before. John, you may be able to remember this as well. Just recently, our Minister of Justice said that anybody going into a remand facility or just locked up period is to be given the ability to have addiction therapy right off the bat, which actually was a fairly novel approach to look at the opioid crisis, but it just sort of somewhat relates to that point. I just wanted to bring that up.
Thanks, Peter.
Miles, yeah, sir. I just wanted to say one quick thing. It's I forgot to mention it earlier. A bill that went, it was the omnibus bill. I think it was C6 or something. That was going through the. Oh, sorry, I believe it was C9. Could have been C19. I'm sorry. That was passed earlier this summer. It was an omnibus bill for funding and whatnot, but there was a subsection on promotion of anti-Semitism. I had done at our last meeting, I had presented on it a little bit, but it has passed. So section 319 of the criminal code has been amended to specifically include anti-Semitism. It does not look like they really took the Senate's suggestions into account. It looks like it's pretty well what was originally proposed. So, yeah.
Thank you, Brendan. We appreciate the update. Anything else, folks? All right, thank you very much. So we'll see you all here back. I believe it's on November the 8th. Same time, same channel. This is recorded, so I'll post it for everybody to take a look at for the rest of the week. And again, thanks everybody.
Thank you.
Take care,
Thank
now.
you.
Thanks,
Stay healthy.
everyone.
Thank you. Bye-bye.
Bye.
Bye now.
Stay well.